Hi. I am going to try to do some very, very fast jury for you. I know that there's not a lot of very fast dictation out there just to listen to. So I'm going to do 300 words a minute. I'm going to attempt to jury charge, which will be pretty standard, but we'll have some of those new words that I just recorded another video on, like Facebook, Twitter, Instagram, all those kinds of things. So let's get some endurance and some speed. Ready? A few moments ago, you took a note that will govern your conduct as jurors between the time you took that oath and the time that you are discharged by me after you have rendered a verdict in this case. The oath and the rules of court obligate you to do certain things and to avoid other things, and I want to review your obligations for you now. First, you must decide the case based only on the evidence presented here in court and on the laws as I explain them to you. Second, do not make up your minds about what your verdict will be until after you have heard all of the evidence, the closing arguments of the attorneys, and my instructions on the law, and after that, you and your fellow jurors have discussed the evidence. Keep it up in mind until that time. There are some rules that flow from these obligations, and I'll go over them now. You may not perform any investigations or research or experiments of any kind on your own, either individually or as a group. Do not consult any dictionaries for the meanings of words or any encyclopedias for general information about the subject of this trial. Do not look up anything on the internet concerning information about this case or any of the people involved, including the parties, the witnesses, the lawyers, or the judge. Do not get copies of any statutes that might be referred to in court. Do not go to the scenes where any of the events that are the subject of this trial took place, or use internet maps or Google Earth or any other program or device to search for or view any place discussed during the case. Why? Because the parties have a right to have the case decided only on the evidence they know about and that has been introduced here in court. If you do some research or investigate or experiment that we don't know about, then your verdict may be influenced by information that has not been tested by oath to tell the truth and by cross-examination. The same is true of any media reports you may come across about the case or anybody connected with the case. If you do come across any reports in the newspaper or a magazine or TV or any internet site or blog, you may not read or watch them because they may refer to information not introduced here in court, or they may contain inaccurate information. You may not discuss the case among yourselves, including anyone involved with the case, until the trial is over and you have been discharged as jurors. Anyone else includes members of your family or friends or co-workers. If you wish, you may tell them that you are serving as a juror, but you may not tell them anything else about the case until it is over and I've discharged you. You may not talk to any of the court personnel, such as marshals or clerks, about the case. Why is that? Because they haven't heard the evidence that you have heard, and in discussing the case with them, you may be influenced in your verdict by their opinions, and that would not be fair to the parties, and it may result in a verdict that is not based on the evidence and the law. You may not communicate to anyone any information about this case. This includes communication by any means, such as text message, email, internet chat rooms, blogs, and social websites, such as Facebook, MySpace, YouTube, or Twitter. The parties are entitled to a fair trial rendered by an impartial jury, and you must conduct yourself so as to maintain the integrity of the trial process. When you have rendered a verdict and been dismissed by the court, you will be free to discuss the case with anyone you wish, though remember that you are not required to do so. Until then, you must be focused solely on the evidence presented in the courtroom and your obligations to the fairness of the proceeding. In addition, you may not talk to each other about the case until I tell you to do so, and that will not be until after you have heard all of the evidence, you have heard the closing arguments of the attorneys, and you have heard my instructions on the law. You are to apply the facts you find to be true. Why is that? It may seem only natural that you would want to talk about the case as it is going on. The problem with that is that when people start discussing things, they take positions on them and express opinions which are often hard for them to change later on. So, if you were permitted to discuss the case while it is going on, you might reach conclusions or express opinions before you have heard all of the evidence or heard the final arguments of counsel or heard the law that you must apply. Your verdict in the case might then be improperly influenced by the conclusions or opinions you or your fellow jurors have reached before you knew about all of the evidence or the law that will help you put that evidence in the proper context for your verdict. What happens if these rules are violated by a juror? In some cases, violations of the rules of juror conduct have resulted in hearings after trial at which the jurors have had to testify about their conduct. In some cases, the verdict of the jury has been set aside and a new trial has been ordered because of jury misconduct. So, it is very important that you abide by these rules. If someone should attempt to talk to you, please report it to the clerk immediately. If you see or hear anything of a prejudicial nature or that you think might compromise the proper conduct of this trial, please report it to the clerk immediately. I prefer that these communications be in writing. Do not discuss any such matters with your fellow jurors. It is useful for you to know what the various parts of the trial are, so that you may be aware throughout the trial what stage of the proceedings is in progress and what comes next. The trial starts with the opening statements by the lawyers. They will state the nature of their factual and legal claims. Opening statements are not proof or evidence. They are merely statements of the claims of the party, so that you will be aware as you hear the evidence of what legal claims each party is trying to establish through the evidence. After the opening statements, the plaintiff will present his evidence by calling witnesses. Lawyers for the defendant and other parties may cross-examine each witness. And after the plaintiff has presented all of his witnesses, the defendant will have an opportunity to present his witnesses if he chooses to do so. Any witnesses presented by the defendant may be cross-examined by the plaintiff's lawyer. I may vary the order of the trial if necessary to keep things running smoothly. The evidence may take a number of days to present. You must wait until you have heard all of the evidence and have heard my charge to you on the law that applies before you make up your minds about any issue in this case. You may not begin to discuss the case even with each other until after you have heard the charge on the law, because your duty is to wait until you have heard all of the evidence and that applicable law before making up your minds and discussing the claims and issues. Once all of the witnesses and evidence have been presented, the lawyers will make closing arguments to you. These closing arguments, like the opening statements, are not evidence. The final step is that the judge will tell you what the legal principles are that apply to the claims that have been made and the evidence that has been presented. That instruction is known as the charge to the jury. At the end of the charge, I will explain to you the process you should use for your deliberations and delivering your verdict. You may, if you wish, take notes during the course of the trial. Some jurors find that taking notes is helpful in keeping track of the proceedings, and some do not. You should remember that your main job as jurors is to listen and observe the witnesses. If taking notes would distract you from that job, then don't take notes. There is no need to try to take down the testimony word for word. If during your deliberations at the end of the case you need to hear what a witness said, we have an official tape recording or court stenographer's record that will give you an accurate record of the testimony. You should not allow note-taking to interfere with your attention to the testimony or your task of sizing up the witnesses as they testify. But you may take notes if doing so would aid your memory. You should not make any notes outside of court and bring them here. Your notebooks will be collected at the end of each break and kept secure by the clerk. No one will look at them. I take notes because I may ask to rule on issues during the course of the evidence. Your decision whether or not to take notes at any point should not be influenced by my note-taking. You should not disclose your notes to anybody during the trial. It will be up to you whether you disclose them to your fellow jurors during deliberations at the end of the trial. In most trials, only the lawyers and at times the judge ask questions of the witnesses. The jurors do not have the opportunity to ask questions. In this case, I have decided that it may be useful that you have that opportunity as well. This is the procedure that we will follow. After the lawyers have each finished questioning a witness, I will have the marshal collect from you any questions that you may have written down that you would like the witness to answer. I will review those questions out of your presence. If they are questions that are permitted under the rules of evidence and under the rules that apply to trials such as this one, I will ask the question or the substance of it to the witness. You should not take it personally or make any adverse inference should your question not be asked. The lawyers will then have the opportunity to ask the witnesses any questions that follow from that question and answer. Under the rules of juror conduct, you must not speak to anyone about any aspect of this case while it is in progress. You will be instructed to use only certain routes to the courtroom to avoid contact with parties, witnesses, and lawyers. While the court staff and I will greet you and give you any necessary instructions, we will not be permitted to talk to jurors about the case while it is going on. Similarly, the lawyers are bound by a rule of professional conduct that forbids them from having any contact with the jurors during a trial, so you should not hold it against any party or lawyer that they maintain their distance and do not converse with you if you see them in the building. Jurors are supposed to decide the cases strictly on the basis of the evidence and the law presented in court, and these rules exist to keep away any outside influences of any kind. One day you were called in for jury duty. You were probably required to be at the courthouse at 8 a.m. or so. During the trial, you will be requested to be here from 10 a.m. to 5 p.m. unless you are advised otherwise. There is a lunch and recess between 1 and 2 o'clock and a 15-minute break mid-morning and mid-afternoon. If there is any change in that schedule, I will advise you. During the course of the trial, you cannot have any communication with the judge, me, except in open court and on the record. If some issue such as a sudden illness occurs while the trial is in progress, you should write a note and give it to the court staff, who will give it to me and respond to the record if need be. If some emergency occurs at some time when the court is not in session, you should call the jury administrator, whose phone number is on your jury notice, and explain that you are a member of the jury in this courtroom and indicate what the problem is. Obviously, since you have been chosen as a jury, it is your duty to be here every day that the case is on trial. And you can imagine the inconvenience to everyone else if a juror fails to be here punctually. In the unlikely event that there is some emergency or problem, I have just described the procedure to follow. We will now adjourn the trial for the day. Remember that you must obey the rules of juror conduct. You will be going home to people who will be curious about the case and about the trial. Remember that you have taken that oath that obligates you not to talk to anyone about the trial or its issues until after you have rendered a verdict. That means that you cannot talk to members of your family about it. There are no exceptions. Though your oath should be reason enough to obey this instruction, let me suggest to you a further practical reason. If you were to violate your oath and discuss the case at home or with others, they might give you ideas or details from some similar circumstances, and then you would have the problem when you start your deliberations of trying to sort out which information you heard in the courtroom and which you heard somewhere else. Jurors often find deciding issues to be difficult enough without having the added problem of trying to filter out information that they obtained improperly, and that was not part of this trial. Do not talk to anyone about this case or let anyone talk to you about it.